Assalamualaikum warahmatullahi wabarakatuh. My name is Wardina Alia binti Wadilia. Today, I will be explaining about the main objectives of Anti-Sexual Harassment Act 2022 and how does it complement with the Employment Act 1955. The first objective is establishing a tribunal for sexual harassment. The Act sets up a tribunal for anti-sexual harassment under the Ministry of Women, Family and Community Development to hear complaints of sexual harassment efficiently and affordably without requiring legal representation. How does it complement? It ensures impartiality and increases trust in the system, especially if the employees are afraid to report to their employer. The second one is broader legal support for victims. Under the Employment Act, an employee must report harassment through their employer's internal system. However, if the employer fails to act or the employee doesn't feel safe, their options are limited. This is where the Anti-Sexual Harassment Act 2022 complements it by giving victims the option to file a complaint directly with an independent tribunal outside the employer's control. This widens access to justice for employees. Is stronger enforcement and remedies. While the Employment Act only allows the employers to take internal actions like warnings or dismissal, the tribunal can order remedies like compensation, public or private apology, or other specific actions. It provides stronger and more meaningful outcomes for victims beyond what employers may be willing or able to offer. The next objective is improved accessibility and confidentiality. Sometimes, employees are afraid to report cases to their employer, especially if the harasser holds a position of power. The Anti-Sexual Harassment Act provides a safer channel to report cases confidentially and without needing a lawyer. This complements the Employment Act by making the complaint process more accessible and less intimidating. The last objective is promote awareness and preventive measures. Both acts support the prevention of sexual harassment, while the Employment Act requires employers to provide a safe work environment. The Anti-Sexual Harassment Act goes further by encouraging nationwide awareness and education campaigns. Together, they promote a stronger culture of zero tolerance against harassment at every level of society, starting in the workplace.
Now, let's take a look at the 5 main types of sexual harassment that are recognized commonly under the workplace current legislation, including the Malaysian Employment Act and also the Anti-Sexual Harassment Act 2022. First, we have verbal sexual harassment, which this refers to unwanted comment or speech of the sexual nature. It could include things like inappropriate jokes, unwanted flirtings, and also sexual remarks. According to Section 2 of Anti-Sexual Harassment Act, this can be concluded or considered as verbal conduct of a sexual harassment that is offensive or humiliating. Second is non-verbal sexual harassment. This type involve gesture or body language that are sexually suggesting. For example, winking, leering, or mimicking sexual acts. These fall under gestural or non-verbal conduct as defined in the law. Third, we have physical sexual harassment. This includes of unwanted physical contact such as touching, hugging, or brushing against someone. Not only is this covered under the Anti-Sexual Harassment Act, but it can also amount to criminal offences under the penal code such as under section 354 for outrage of modesty. Next is visual sexual harassment. This involved by using visual content like showing inappropriate videos or images that are sexually in nature, even displaying an offensive poster or picture in the workplace or in the company. It can also be considered as one harassment if it's unwelcome and offensive. And finally is cyber and also online sexual harassment. This is increasingly common and includes sending explicit message, image, or commenting via digital platform or device. While the Anti-Sexual Harassment Act didn't mention the word cyber directly, but the law clearly includes any sexual harassment through verbal or visual conduct, even if done online. All these types of harassment are legally defined under Section 2 of the Anti-Sexual Harassment Act 2022, which provides a broad and inclusive framework to protect individuals from any unwanted sexual conduct, whether in person or online, verbal or physical. Recognizing these categories is crucial for creating a safe and respectful workplace.
Next, I will be talking about some of the common challenges in enforcing workplace sexual harassment laws, especially in informal or non-traditional work settings. Let me begin with one major issue, which is cultural and social stigma. In many communities, especially where workspaces are less formal, talking about sexual harassment is still considered as taboo. Victims are often blamed, shamed, or pressured to stay silent. This fear of social judgment discourages them from speaking out, even when the law is on their side. Next, we have the lack of awareness of legal rights. Many workers, especially in informal sectors like domestic work or freelance jobs, simply do not know what protection exists for them. On top of that, some face language barriers or do not have access to proper legal guidance. So, even if something happens, they may not even realize they have the right to report it. Another big challenge is the unclear employer-to-employee relationship. In the informal sector, people may not have official contracts or a clear boss. For example, a food delivery rider might technically be self-employed. So, if they experience harassment either from customer or within the platform, it is not always clear who should be held responsible. Now, when it comes to reporting, things get even more complicated. Unlike formal workplace with HR departments or clear procedures, many informal jobs do not have any system at all. Workers do not know where to go, or worse, they might have to report to the very person who's causing the problem. This creates a situation where harassment goes completely unreported and unresolved. Lastly, there is the fear of retaliation. In this kind of jobs, work is often unstable. People are afraid that if they make a complaint, they will lose their job, get blacklisted, or be treated unfairly. And unfortunately, this fear is often justified, especially when there are no strong protections in place. So, to summarize up, even though sexual harassment laws exist, they often don't reach the people who need them the most. Social pressure, lack of awareness, unclear roles, weak reporting system, and job insecurity all create serious barriers to justice, especially for those working outside the traditional office setup.
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Mukris Afiq bin Mahathir. Today, I will be talking about the effectiveness, or rather ineffectiveness, of Malaysia's workplace sexual harassment laws. Firstly, until recently, there was no specific law to deal with sexual harassment in the workplace until 2022. Laws were scattered across the Penal Code and the Employment Act. And the only official guideline is the 1999 Code of Practice, was voluntary and adopted by less than 0.1% of companies. Secondly, there is a huge issue with underreporting. In 2023, only 23 cases were officially reported. Victims often don't come forward due to fear of retaliation, job loss, or lack of trust in the system itself. Third, legal process itself is a barrier. Civil suits are expensive, emotionally exhausting, and can take years. Many victims either drop their cases or never file at all. Fourth, employers had no legal obligation to to prevent harassment or train staff, which led to low awareness and normalized misconduct in workplace. Lastly, Malaysia's laws were fragmented and gender blind. They focused too much on punishment and ignored key aspects like prevention, victim support, and the power imbalance between staff and superiors. For this part is statistic that prove that the law is ineffective. Now let us look at the numbers that support the claim that the law is ineffective. A 2020 WAO study found that only 62% of Malaysian working women have experienced at least one form of sexual harassment at work. Other studies from 2021 to 2023 estimate between 35 to 53% of working women face harassment, depending on the method used. The 2023 survey revealed that 70% of Gen Z and 61% of millennials in Malaysia had experienced some form of harassment or microaggression in the workplace. While this number shows that harassment is widespread, only 23 official workplace cases were reported in 2023, as I mentioned before. This huge gap shows that most cases go unreported because of fear, shame, or no trust in the complaint system. Even male victims are underrepresented. In 2023, police data showed only 4% of total sexual harassment reports involve male victims, although some studies found 2% to 6% of male healthcare professionals had experienced it too. This test proved that Malaysia's existing legal framework has not protected victims effectively, and that without stronger enforcement, proper training, and dedicated sexual harassment law, the problem will continue to be ignored. Thank you.